SJC-11438, Patricia Silva v. Nancy Carmel.
Thank you.
Okay, let's proceed. Good morning.
Good morning, Mr. Chief Justice, Associate Justice, may it please the court. My name is Fred Misilo. Accompanying me is Marissa Higgins. We represent Nancy Carmel. I'd like to reserve 5 minutes in rebuttal. First, I'd like to start out by acknowledging there's a misstatement in our brief which erroneously identified Chief Justice Ireland as the author of the minority opinion. In turn of Lewis, I apologize, Your Honor.
That's quite all right. It was Justice Cowan, as I recall.
Exactly, Your Honor.
They get confused all the time.
We're here asking this court to vacate a final abuse prevention order from the Newton District Court against my client, Nancy Carmel. Nancy Carmel is an individual, is a person with an intellectual disability with behavioral challenges. She's under guardianship. She's 48 years old.
Is she still a client? I know this isn't this record, but is she still a client of DDS?
Yes, she is.
And has a residence that they are
After
providing?
14 months of significant issues, she has found another residence. Christina Silva is also a person with an intellectual disability who is also under guardianship. Both Nancy and Christina live together in a group residence licensed by the Department of Developmental Services with 2 other women with intellectual disabilities, operated by Riverside Community Services. A 209 abuse petition was brought on behalf of Christina Silva by her mother, her guardian, following an incident between Nancy and Christina in their group home. After a hearing before Judge Klein in Newton District Court, an order was issued, which resulted in Nancy being removed permanently from the home. 209A is the wrong remedy here. A group residence licensed by the Department of Developmental Services is not a residence, not a household, as contemplated under Chapter 209A. Hence, the parties cannot be considered household members under Chapter 209A. DDS has a robust regulatory appeal process where individuals can appeal their ISPs, can request for modification of their ISPs for transfers.
What happens in these, I don't want to overstate it, but emergency situations? What do they go through? A year of appeals and reconstructions of the ISP? Meanwhile, this dangerous relationship survives?
That's good. That's an excellent point, Your Honor. No, absolutely not. There are remedies built within the ISP modification regulations, as well as the ISP appeals, that allows for an individual to be removed from the program administratively.
How are those triggered?
Those
How is
appeals.
that triggered?
That's triggered either by program staff or by initiation by an affected consumer. I would also point out beyond...
So how does the affected consumer do it? Like in this case, how would Mrs. Silva do that?
She could have appealed her ISP. She could have requested a modification, and in the course of
Isn't that months,
requesting that...
though? Or
Excuse me?
I mean, doesn't that take a long time?
Arguably, the issue that you're raising is, well, what option does Ms. Silva have? Does she have to go through this laborious administrative process?
It's Justice Cordy's question about emergency situations.
And there's a third point that I would make, in addition to the administrative appeal process, which is that both of these individuals were under guardianship. Both of these individuals had the ability, or one of these individuals had the ability to seek the equitable protection of the probate court to use 209A, which is intended to be a domestic abuse statute, to prevent violence as between domestic members, is a misapplication of Chapter 209A.
Counsel, just by way of background, I'm interested in how long these 2 people lived under the same roof.
Approximately 2 years, it's my belief.
And how many people altogether were under the same roof with them?
There were 4 people. There were two staff present at all times, and there was a staff person there during the evening.
So these four people lived together for 2 years. Would it be fair to say they were in the same household?
They were in the same residence. Now, and I think there's a huge distinction between a common law household as contemplated under 209A. 209A was meant to address the evils associated with domestic violence, emanating from family settings, relationships, marriage, common parentage, substantive dating relationships. In a licensed group home, the residents share really only one thing: it's a common diagnosis. They were brought together because of their intellectual disability. They applied for services, they were found eligible and prioritized for those services by the Department
Well,
of
did they
Developmental
function
Services.
independently, or did they, for example, did they eat their meals together?
It's a group residence for sure. There are some family-like activities for sure, but the core aspect of a group residence is the development of an individual service plan to advance their skills, their abilities, to promote their health and their safety. These are state-created facilities. These are facilities that are funded entirely by the Department of Developmental Services. They are really part of what happened to the institutional settings when 209A was established in 1978. The vast majority of DDS's resources was in the institutions. And so the institutions have been closed, and the monies have flowed from those institutional settings into these community-based programs. These are simply not households for purposes of applying Chapter 209A. They're not intended.
What happens to somebody who is just, I hate to use the word incorrigible, but who can't live with anybody, and they get moved from house to house to house, and what happens when you get to the last house?
Well, the Department of Developmental Services and its providers have extraordinary clinical insight and extraordinary clinical expertise to deal with a wide variety of individuals. And certainly, they have the ability to do that. And there are extensive administrative provisions with regard to transfers. There's appeals to the Division of Administrative Law Appeals. So the question comes down to, if we allow the district courts, which are courts of limited equitable jurisdiction, to hear these cases cry out for equity. Both parties are harmed, both parties. My client is a person with an intellectual disability, with behavioral issues. She went to this residence seeking help. And after receiving services, she went to the district court and was handed an abuse order, and she was put on the registry as a domestic abuser.
Well,
If we could just go back again, I'm trying to envision this. So you've got these four people who live in the same residence. They have two caretakers who are with them. Is this like a house?
This is a home.
This is a home.
This is a house. This is a house
The
structure.
house.
That's
So
correct.
they share the same space,
Yep.
the same bathroom facilities, same kitchen areas. That's where they eat, they sleep, they do all of their things, and do have a common television area or
Yes.
something, like a living room and all of that.
Yeah, they're supervised by staff, that's correct. They have an individual service plan that's developed for their own specific needs.
Now, if you're right, there would still, I would think, be a remedy for a plaintiff in this situation, which is you could go to Superior Court, you could bring a complaint alleging assault, and you could seek a temporary restraining order.
Well, certainly there's tort remedy. I would suggest that the equity court of the probate court is the most appropriate forum for this type
So
of
the
issue.
issue is not that there's no remedy in court, and with all the problems which you describe with the courts getting involved, you're just saying it's not a 209A remedy.
That's exactly right. The plaintiff was entitled to relief, but it wasn't in the district court with limited jurisdiction to only look at her issue. When my client was before, and they were pro se at this time, when my client was before the judge, there was no consideration of my client's intellectual disability, her complex clinical needs.
Was your client's guardian there?
Yes. And they raised the jurisdictional issue, it's in the transcript. They raised the issue that this has been a problem for 2 years, that they're trying to work out. And the judge said, well, this is a court issue.
But to go to, yes, but with your answer to Justice Gantz that, yes, you have a court remedy, just not this one.
Yeah.
I mean, you're still going to have the situation where if as, you know, the record certainly is not without support, that there was a very dangerous situation.
In the probate court, Your Honor,
But your client would have to move, is my point. Wouldn't that happen?
no. There are other opportunities to work out the clinical complexities within perhaps the probate court.
But how?
Well,
What
first,
could the probate court do that the
fashioning-
district court couldn't do in a 209A?
through using its general equitable jurisdiction to work out a plan before the court to subpoena DDS employees, to subpoena vendor employees, to work out a plan that could potentially keep people together. And the court could review that order could be reviewable by the probate court. The probate court has equitable jurisdiction, general equitable jurisdiction. Both of these individuals were under guardianship.
Counsel, we have to leave it there temporarily. Yes, ma'am.
May it please the court. My name is Erin Harris, and I'm here today on behalf of the plaintiffs at the district court level, Patricia Silva, who is the guardian and mother of Christina Silva, who at the time was a 34-year-old woman with developmental delays. It is our position today that these two individuals, Ms. Silva and Ms. Carmel, qualify as household members for the purposes of 209A protection.
Where do you fit them in? How do you fit them in?
I think we fit them in under the ever-changing definition of families and household members, both in the Commonwealth and in other states across the nation. Now, this court, in a number of cases, has recognized that this definition is changing and that the statute needs to be flexible in order to accommodate that.
Well, when we look at 209A, where does it say anything about a situation like this?
Individuals who reside together in a household. The facts of this case establish that we have two individuals for a period of a minimum of 2 years resided together in a home. This is a home that had common areas such as hallways, living rooms, dining areas, and bathrooms that they shared on a daily basis. Neither of these women could conduct their daily activities without regular and repeated interactions with one another. DDS, in their statements to the public about their purpose and their goals in establishing homes and residences for individuals under their care, has stated, as cited in the community legal brief, a person's home should be preserved as their home.
Well,
and that's what we're asking this court to do, preserve this as Ms. Silva's home.
If you prevail, that's the law of the land, then what about the frat house where people live under the same roof, they share the same common areas, and they eat and they sleep there? They're not related, but would that also be considered a household?
I think it possibly could be, but it is distinguishable from this case because a frat house is typically intended to be for a short period of time. Those individuals are never intending to establish a long-term household relationship.
3 or 4 years.
Yeah,
It could be, but the case here is, I think, more permanent than that. But also in those cases, yes, they are sharing a household as most people know it, eating together, sharing a bathroom, sharing a living area. They cannot conduct their daily activities without regular and repeated interactions with each other. And it's those regular and repeated actions in their daily lives that make individuals in a household or family particularly susceptible to abuse.
But all that's true, but doesn't the fact that you've got, that the household is operated by a state agency and it is, I mean, they are there because it is a program, doesn't that make a difference when you're thinking about 209A? I mean, for example, why wouldn't, if you had I think this is the case, the hospital that's on Long Island, where people are there for a very, very long time. Does 209A apply there?
I think the difference in a scenario like that is that the facility is intended to be there to provide individuals with a service, not to create a home environment. Here, the intention is to create a home environment in which they can also receive those services. So there is a difference in the intent of the facility that we have. With respect to these particular individuals, this was their home. They should not be discriminated against because their home does not meet other individuals' definitions of a home or a household. For better or worse, this was the home for these two individuals. And DDS should not be their sole and exclusive remedy. We have oftentimes instances in which an agency's authority overlaps with that of the court, but that does not take the power away from the court.
What happens though if DDS determined that they could work out a better solution if your client moved out and went into a different facility, and Ms. Carmel stayed in that facility?
That certainly could be within the purview of DDS had this restraining order not issued.
No, even if it did issue.
Even if it did issue, I believe DDS would have the authority to shift my client to another facility if they follow the appropriate procedures for determining under her ISP that another facility was more appropriate, sent a written notice, and allowed her and her guardians an opportunity to object. But DDS did not do that here. And the problem that we have is that DDS for 2 years was aware that there was physical assaults occurring between these two parties, and the remedies available to DDS were not sufficient to prevent Ms. Silva from continuing abuse. The record is clear that there were 2 years of problems. Ms. Silva testified that she tried to work within that system to protect her daughter, but she did not receive that remedy. Her daughter continued to be the victim of physical assaults in her own home, the most recent of which resulted in her being taken to the hospital with a laceration to her head and a sprain to her back and her neck. They worked through those procedures, but those procedures did not address the immediacy of a physical assault such as this.
Would you use a time period to help define the family household relationship? Here it's 2 years. What about 6 months?
I don't think a time frame can be used so much as the nature and the purpose of the relationship, what the parties intended it to be. And in here they intended it to be their home.
So
A married couple could only reside together for 1 month prior to a divorce. However, that still is a marriage and a household, regardless of the duration of time. So I don't think the time period at which it does last is what matters, but I do think the intent of the parties to make it their home for that period is what matters.
So you would include a lodging house?
I think a lodging house is a different scenario, but when we look at the New Jersey cases that are cited too in the community legal brief, probably a more apt comparison would be suite mates in a college dorm, where they have individual bedrooms but share a common area while residing in their own bedrooms. Those individuals were found to be members of a common household because of the things in which they shared in common: the common living room, bathroom, and dining area, and the regular and repeated interactions that they had on a daily basis in order to continue living in that type of environment.
So let's say that a 209A petition or application is filed. What authority does the district court judge have to do something short of either issuing the order or not issuing the order? Is there something that can be done in that context that would be more clinical as opposed to sort of using a sledgehammer?
I don't believe the district court has an alternative remedy to a stay away or vacate order here. DDS is not a party to this restraining order, so DDS has the authority to issue an order relative to these particular individuals and where they reside in their communications and interactions with one another, and that is what was done here. One problem that I think is significant, the defendants are asserting that DDS is the remedy here. However, DDS has two separate remedies. Ms. Silva has her ISP and her guardians and her plan with DDS. And then on this side, we have Ms. Carmel and her guardians and her ISP. There is not a mechanism or procedure in which both of those are evaluated together and that the rights of the parties are concurrent.
Well, neither does 209A offer that, does it?
209A allows us to bring these parties together in one legal proceeding in which they are both subject to the jurisdiction
And
of the
one
court.
wins and one loses. I mean, there's no play there.
And unfortunately, that's the reality of a 209A order for both individuals in a DDS facility as well as those who are not. Any individual who is ordered to vacate their home where they may reside with their spouse and their children, leaving with nothing but the clothes on their back, suffers a hardship. And that's why we have procedural hurdles and a burden of proof on the plaintiff to ensure that these orders are not issued lightly because they have significant consequences.
Well, I'm just thinking about the broad thrust of your position. What about a nursing home where you have people who live under the same roof, they eat in the same area, they share the common space? If there is a situation where one resident just routinely gets into a fight with another, could a judge issue the 209A and thereby cause that resident to have to leave the nursing home?
I do think there are instances, depending on the particular setup of that home, in which it occurred. But nursing homes are very varied. It could be in a small residence with 4 individuals, up to hundreds of individuals who may never have to see each other on a day-to-day basis. So it's tough to analogize that to this situation without knowing more about the particular nursing home. But knowing this case, we have 4 individuals in a single home.
But you talked about regular and repeated interactions, and I'm just speculating that
Right.
might be a situation in a nursing home.
And I do believe that the situation could occur in certain types of nursing homes and in certain setups of nursing homes, without a doubt. But to some extent, that is factual, depending on the particular nursing home and how it's set up with its common areas and how frequently the parties in that particular nursing home would have to encounter one another.
Justice Cordy has a question. And
that's
then
it.
Justice Spina?
All right, let me try to answer it quickly. First of all, so how do we better understand what the legislature intended here? Do you think the legislature intended it to apply to DDS-funded facilities such as this?
I do think so. I think the legislative history indicates that they intended this to be a broadly encompassing statute. There have been repeated amendments to the statute, and each time it has been amended to broaden and add more flexibility to the terms of family and household members. And the reason is that individuals who are in a family and household environment are more susceptible to abuse. And that is what we have here, someone who is being abused within the confines and 4 walls of her own home. With respect to
So if it was a
DDS,
say if it was a DYS facility where it was run by DYS, run by the state, and you've got maybe 8 or 9 juveniles living in there as part of a sentence of some sort?
and again, similar to the nursing home, it could be the same scenario where they could qualify. I think the most analogous here might be 2 children from separate families who are put together in a foster home. They're living together with the same foster parents, sharing a household environment, but they're not related by blood, they're not related by marriage, and neither of those foster children selected that home. This state selected that home for them. If one of those children was beating or sexually abusing the other child in that home, I don't think the court would deny them the remedy of a 209A restraining order. And I think that is a very analogous situation to what we have here, because it is a state-run facility. It is a state-mandated appointment or placement in that facility with individuals not related by blood or marriage. And I don't think this court would deny them that opportunity.
Did the department seek to intervene, or did it express any views in the lower court?
No, they did not. My client reached out to them to obtain a letter or any sort of documentation, but they did not provide her with anything.
And are there any administrative proceedings pending to move people around?
Not at this time. I believe my client is still at Riverside, and the intention is that she stay there. And another facility has been located for Ms. Carmel. Throughout the 2 years leading up to the restraining order, yes, DDS was actively involved, and they were trying to put plans and systems in place to prevent problems from occurring between these 2 women. However, it didn't succeed.
Could the department have moved one of these 2 people around as quickly as the 209A order had the effect of doing?
No. If there is an emergency system, there is a protocol that they can follow. It's at least 8 hours worth of notice, but again, there is a procedure by which the guardians and the individual subject to the plan can challenge that, and they have due process rights. So it is not as speedy as the remedies available to the court. And it's also not a procedure that would incorporate Ms. Silva and Ms. Carmel together in the same proceeding. It would be a challenge to either Ms. Carmel's ISP plan and placement or to Ms. Silva's ISP plan and placement. It's really not looking at them comprehensively and together.
But there is a procedure in Superior Court to have it be decided as a TRO. We would do that every day in Superior Court. People would come in, neighbors would come in seeking TROs. They'd be heard at 2 o'clock by the pro se judge. Why is that not an appropriate resolution of this problem? There still is going to be a court adjudication of it.
There still is an appropriate remedy in Superior Court, but there is some concurrent jurisdiction among the courts when it comes to 209A restraining orders.
Also the probate and family court too, right?
I don't see that the probate and family court necessarily has jurisdiction here. They have jurisdiction over my client and her guardians or over Ms. Carmel and her guardians. There is no case or proceeding in the family and probate court that incorporates both of these individuals and their respective guardians and plans. That's not the remedy here.
Is there any reason why the department hasn't filed an amicus brief in this case?
Not that I'm aware of. I think it would have been quite helpful for all of us to have seen them involved here and at the district court.
Is there a concern? Well, I have this concern, which you can answer. Do we dilute the standards of 209A by enlarging the scope of households? That is, and right now in 209A, we would never say if a woman is being threatened that she would have to leave the home. If that turns out to be easier, we would always have the abuser leave the home. And the only issue is the safety of the person involved, not the more complicated issues which are at issue here. So, I mean, if we begin to expand this to include this, are we going to be messing up our jurisprudence with regard to 209A?
I don't believe so, Your Honor, because I don't see this so much as an expansion as it is a denial of the defendant's request to define it in a more narrow manner. Household is a broad term, and looking at these parties here, they reside together in a common home with the intent of living there and spending their day-to-day lives in that residence that is shared. So I don't think it is overly broad. I think it is very much within the purpose of our legislative intent in protecting individuals from domestic violence.
Thank you, counsel.
Thank you, Your Honors.
Your Honor, there are 2 points I would bring out initially, even though there was this 2-year process. To my knowledge, there's nothing in the record that an ISP appeal was filed by the Silvas, nor was there a request to modify the ISP that would have merited a transfer of Ms. Silva.
So according to the department, everything was hunky-dory.
Well, I can't speak for the department. I think that the department would ask if people wanted to exercise their rights to exhaust their administrative remedies under the DDS regulatory structure. It's up to the parties to initiate a fair hearing. An ISP appeal is before a fair hearing that eventually could make its way to 30A.
But the problem is that this isn't her ISP. Her ISP isn't the problem. It's someone else's. I mean, this is not the problem. The problem is that my ISP is fine. This is exactly where I ought to be living. This is exactly the kinds of services I ought to be getting. My problem is there's someone else living here
So I'm
who's abusing me.
Exactly, Your Honor. And then by having 209A be applicable in these situations, we're encouraging a race to the courthouse.
Can I ask you this? What can you explain to me? Ms. Silva's attorney says there is no jurisdiction in the probate and family court. How would you get there?
I think that there is general broad equity jurisdiction, I believe, under Section 5 or Section 6 of the statute.
You can get. I mean, the Superior Court certainly does. And you think that under Section 6 you can get a temporary restraining order even?
Sure. Why not? I would think that's part. It's a court of equity jurisdiction.
Yeah, but is it a court of general equity jurisdiction?
Sure it is.
Under Chapter 214, Section 1, it has all the powers of the Superior Court to issue equitable orders?
No. But it has the authority to exercise equitable jurisdiction as towards under its control, under the incapacitated persons,
So it would be
people under guardianship.
through the status as a ward of the court
That's correct.
or a ward of the guardian. But anyway, but supervised in a way because the guardianship is by the court.
It's one option. There's one option.
How would that work?
Yeah.
Could you just explain that? So you go to probate court, you say, I'm having a problem with this person, then probate court would do what?
Well, the probate, what I would, if I was defending the defendant in that case, I would appear at the hearing with subpoenas to the Department of Developmental Services, to Riverside, with my own expert witness, and ask for a full hearing before the court to determine the appropriateness of the setting and have a review of what should happen in that setting. That didn't happen in the district court.
Well, wouldn't probate court have to then review both residents' situations
Yes, Your Honor.
and get information about both of them?
Yes, and Your Honor, the core aspect of a restraining order and injunction is an equitable relief. In the tradition of Cheney versus Packaging Industries, we should be looking at, the equities on both sides, not just on one side. The other argument that I think is compelling here is who has the resources? Really, who has the resource to deal with these thorny issues? In 1978, when this statute was created, there were very few of these types of group residences, and the courts were not challenged. I don't believe that it would be appropriate for the court to think that 209A was considered, that considered limited group residence at the time it was created. It was focused on preventing domestic violence. If the court extends Chapter 209A to these types of settings, then we have Department of Mental Health group homes that would be part of this. There are special education residential schools that have dormitories, Perkins School for the Blind, Riverview School down the Cape. They all have dormitories. How would we distinguish those settings from Department of Developmental Services licensed settings? It would be the same thing. I would offer a bright line test. And the test would be, to the extent that government creates, funds, regulates, licenses, and selects residents of a group living setting to primarily receive services, it's not a household for Chapter 209A. When individuals share a common diagnosis or status rather than marriage, blood, or the other familial relationships that are identified in Chapter 209A, that's not a household. Based on the foregoing, I'd ask this court to vacate the final abuse prevention order issued by the Newton District Court against Nancy Carmel, but also ask this court, if it's inclined to do that, to expunge her name from the domestic violence registry system.
Thank you, counsel.